Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court has ruled that a person who is entitled to receive compensation by way of claim before the Motor Accident Claims Tribunal cannot be said to have given up his status as an indigent person by virtue of the amount slated to be received. A division bench of Justice Sanjay Karol and Justice Arvind Kumar allowed the appeal against Gujarat High Court order denying the appellant permission to seek enhancement of compensation amount as awarded by the MACT. The court observed that the ground upon which the claimant's application to file the appeal as an indigent person was rejected is contradictory to the impugned order, as it was recorded in the submission of the counsel for the claimant that no money was paid to her at the point of time. The Supreme Court has quashed an order passed by the Allahabad High Court stating that the employees of the Nagar Nigam are not covered under the Employees State Insurance Act 1948. A division bench of Justice B.R. Gavai and Justice Sandeep Mehta stated that rather than interfering in the matter, in the exercise of jurisdiction, the Nagar Nigam should have been delegated by the single judge to approach the insurance court by filing an application under Section 75(1)(g) of the Act of 1948. Examining such an issue would require the collection of evidence and the appreciation thereof. Hence, only the insurance court constituted under Section 74 of the Employees State Insurance Act of 1984 would be in position to examine such disputed questions of fact, the court stated. The Supreme Court has issued notices on the 7 petitions challenging the conduct of the NEET UG 2024 examination mired by controversy this year. One of the petitions sought a probe by the Central Bureau of Investigation into the alleged paper leak. The court issued notices to the Center and National Testing Agency or NTA on the petition seeking the CBI probe into the irregularities in NEET UG 2024. The court also issued notices to private parties on petitions by the testing agency seeking the transfer of cases pending in various high courts on the NEET UG row to the apex court to avoid multiplicity of litigation. The court directed the same to also come up on the same date. The vacation bench of Justice Vikram Nath and Justice Sandeep Mehta took note of the submissions of the NTA Council and several petitions seeking cancellation of the National Eligibility cum Entrance Test Undergraduate 2024 on the allegations of question paper leak and other malpractices are pending in several high courts. Now let's have an overview of high courts. The Guwahati High Court has ruled that in absence of any other evidence, conviction cannot solely happen on the basis of admission in unsigned confessional statements. The court stated that as per Section 164(4), the confession statement of the accused person shall be signed by the person making the confession, but in the present case, the accused did not sign the said confessional statement. Non-compliance with provisions of Section 164 CRPC caused injury to the accused in his defense on merit, and the same cannot be cured at the later stage. The Madhya Pradesh High Court has opined that the testimony of hostile witnesses are also having the importance if they are supporting the prosecution case to some extent. Further, evidence of a person does not become wiped out from the record merely because he or she has taken a U-turn in the court and relied from his original statement. The bench expounded that as per the human tendency, a close relative would put forth the actual story of incident rather than hide the actual culprit and foist an innocent person. Virtually in many of the criminal cases, it is often seen that the offence is witnessed by close relatives of the victim, whose presence on the spot of incident would be natural, and the evidence of such witnesses cannot automatically be discarded by levying them as uninterested witness. The Patna High Court, while dismissing an appeal filed against the order passed by the single judge, held that disputed question of facts cannot be adjudicated while exercising the extraordinary jurisdiction under Article 226 of the Constitution necessarily when evidence is required to prove the claim. The court further said that earlier the petitioner had filed a writ petition for identical relief which came to be withdrawn with the liberty to pursue his remedy before the DCLR, and the same cause of action subsequently another petition has been filed which is not permissible. The division bench of the Madhya Pradesh High Court, comprising of Justice Vivek Rushia and Justice Rajendra Kumar Vani, has granted divorce to a woman whose husband has been convicted and sentenced to life imprisonment for murdering his own father over a property dispute. The court looked for the merits of the case, and which was dismissed by the family court, and expounded that the family court has wrongly dismissed the case relying on the condition prior to the registration of a criminal case and conviction when a wife cannot live with her husband in future because the uncertainty of releasing him on bail. The court further pondered on the sole issue and paid reliance to the precedents and observed that because of the aggressive nature of the respondent husband, while facing trial under Section 307 of IPC, and therefore he murdered his father, now he is convicted under Section 302 of IPC. It would cause constant fear about the safety of herself and her minor daughter in the mind while living with him. The single judge bench of the Jharkhand High Court has held that the test of sameness is to be applied to find out whether both the FIRs relate to the same incident in spite of same occurrence or are in regard to the two incidents which are two or more parts of the same transaction, and if the answer is affirmative, the second FIR is liable to be quashed. The court furthermore held that only on the ground of certain new alleged allegations, the second FIR was further not maintainable. Based on these considerations, the court was of the view that the continuation of the second FIR would amount to abuse of the process of law. Moving on to international news this week. The European Union's top court has slapped Hungary with €20 million fine and imposed a daily €1 million penalty for failing to follow the bloc's asylum laws and for illegally deporting migrants. Hungary's anti-immigrant government has taken a hard line on people entering the country since well over 1 million refugee and asylum seekers entered Europe in 2015, most of them fleeing conflict in Syria. It erected border fences and forcefully tried to stop many from entering. Luxury firms should beef up checks on the suppliers to ensure they respect labor laws, according to Italy-wide proposal from Milan's Court of Justice following worker exploitation probes involving units of LVMH's Dior and Giorgio Armani. The proposed scheme, which would not be legal binding, marks an attempt by a magistrate in Italy's fashion capital to tackle what they have described in documents a generalized manufacturing method that put people's lives at risk to boost profit margins. Milan prosecutors probed for a decade illegal working conditions in sectors such as logistics and cleaning services before focusing on the luxury sector, where Italy accounts for half of the world's production. Supply chain probes this year uncovered sweatshops near Milan where workers, often illegal migrants, ate and slept, sometimes working through the night and during holidays to operate machines stripped of safety devices to increase output. The High Court of Israel has issued interim orders against the state over the supply of humanitarian aid to Gaza, in effect placing the burden of proof on the government to demonstrate it's providing enough humanitarian supplies to the Palestinian population in the war-torn territory to meet its legal obligations. The state has 10 days to respond, after which the court will likely hold another hearing before making a final ruling. Following a 3-hour hearing, the High Court issued an interim order instructing the state to explain why it should not allow unfettered access to humanitarian aid, equipment and staff into the Gaza Strip in light of the severe humanitarian situation in the enclave amid the ongoing war started by Hamas's October 7th attack. In the end, we have miscellaneous news. Civil liberties activist and Supreme Court lawyer Indra Jaisingh has urged consensus building among all stakeholders before the centre implements the 3 new criminal laws from July 1st as notified. She has cited concerns in people's mind and the constitutionality of some provisions of the Bharatiya Nagarik Suraksha Sanhita, BNSS, Bharatiya Nyaya Sanhita, BNS, and the Bharatiya Sakshya Adhiniyam, BSA, which are to replace the Code of Criminal Procedure, Indian Penal Code, and the Indian Evidence Act. Jaisingh argued that the civil liberties of citizens, such as the freedom of speech, right to assembly, right to associate, and the right to demonstrate, can be criminalized under these 3 codes. She added that while substantive criminal law cannot apply retrospectively, procedural laws like the BNSS and the BSA, which are to replace the CRPC and Evidence Act, may apply to pending cases depending on whether or not prejudice will be caused to the accused. The centre has announced that Arjun Ram Meghwal, BJP leader and 4-time MP from Bikaner, will continue as the Minister of State, independent charges of the Ministry of Law and Justice. Meghwal was appointed at the MOS Ministry of Law in May 2023. He was the 3rd law minister to be appointed in Narendra Modi's 2nd stint as the Prime Minister. As a law minister, Meghwal oversaw the passage of many important laws in Parliament, such as the Mediation Act, the new criminal laws, the Personal Data Protection Act, and the law on appointment of election commissioners and chief election commissioner, as the law on control of administrative services of the National Capital Territory of Delhi. Meghwal is also credited to have been the law minister who put the controversy surrounding the collegium system to appointment of judges to rest, as the appointments made in his tenure were quicker than the previous ones. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.